Good afternoon, everyone. My name is Jan Anthony LOTIVIO Ibeharin, 4th year criminology student from Abra Valley Colleges. I am here today for my oral examination in court testimony about sufficiency of complaint or information, duplicity of offense, amendments and substitution of complaint or information when allowed. And lastly, place of institution of criminal actions. Now, ano nga ba ang complaint and information? What is complaint and information? A complaint is a sworn written statement charging a person with an offense subscribed by the offended party, any peace officer, or other public officer, charged with the enforcement of the law violated. Ulitin ko. A complaint is a sworn written statement charging a person with an offense subscribed by the other offended party, any peace officers, or other public officer, charged with the enforcement of the law violated. That is the complaint. Sa information naman, an information is an accusation in writing charging a person with an offense subscribed by the prosecutor and filed with the court. Ulitin ko. An information is an accusation in writing charging a person with an offense subscribed by the prosecutor and filed with the court. Okay. Distinguish natin yung dalawa. Distinctions between a complaint and an information. A complaint must be sworn, hence under oath. Ganon yung complaint, must be sworn, hence under oath. Ang information naman, no oath required. Bakit? The reason kung bakit no oath required ng information. The prosecutor who subscribed the information is acting under the oath of his office, so therefore it is no longer required. Kaya ang information no oath required na. Dahil sa ang prosecutor ay may under na siya ng oath niya. Ang complaint naman ay subscribed by the offended party, any peace officer or other officer charged with the enforcement of the law violated. Ang information naman subscribed by its prosecutor. Okay. So let's talk about on sufficiency of the complaint or information. Under Rule 110, prosecution of offense, Section 6, sufficiency of complaint or information. A complaint or information is deemed sufficient if it states the name of the accused, the designation of the offense given by the statute, the acts or omission complained of as constituting the offense, the name of the offended party, the approximate date of the commission of the offense, and the place where the offense committed. Okay, what if more than one person who committed the crime? What if more than one person, ha? When an offense is committed more than one person, all of them shall be included in the complaint or information. Ganun yun. Kapag higit sa isa yung gumawa ng offense, kailangan lahat sila ay nakalagay sa complaint or information. In the other way, the complaint or information is sufficient when they answer the four questions of who, what, when, where. Okay, isahan natin sa who. Who? The name of the accused. If it committed more than one, all of them shall be included in the complaint. Kung sino ang mga akusado, kung sino ang akusado o kung sino-sino sila, kung marami sila. The second one is the name of the offended party. Yun yung tanong para sa who. Next is what. What is the designation of the offense given by the statute? And what is the acts or omission complained of as constituting the offense? Third is when. When. The approximate date of the commission of the offense. So when was the offense committed? Kung kailan at kung anong petsa. The last is where. the place of the commission of the offense, kung saan nangyaring lugar ito. So that are the contents and facts that should be included in the complaint or information in order that the complaint or information becomes sufficient for the filing of criminal case. Ganun yun. Here's the tip for you guys, para madali nyong ma-recall yung mga yon. Just remember NDANAP. NDANAP. N stands for name of the accused. Letter D stands for the designation of the offense. A stands for the acts of the omission complained of as constituting the offense. N for the name of the offended party. A for the approximate date of the commission of the offense. Last is P for the place of the commission of the offense. NDNAP, NDANAP. Ulitin natin. N stand for name of the accused. D, designation of the offense. Letter A, the acts or omission. Letter N, name of the offended party. A, approximate date of the commission. P is the place of the commission. Now, let's discuss the content one by one. Let's start. In the name of the accused. Now, what is the rule? How will you state the name of the accused? Under Section 7 of Rule 1110, the complaint or information must state the name and surname of the accused or any affiliation or nickname by which he has been or is known. If his name cannot be ascertained, he must be described under fictitious name with a statement that his true name is unknown. Example, kung hindi nyo alam yung tunay na pangalan ng akusado, kailangan yung gumamit ng pangalan niya kung saan siya nakikilala, kung anong pagkakakilanlan niya. Kumari, Ben Tumbling, yung mga ganong pangalan. If the true name of the accused is thereafter disclosed by him or appears in some other manner to the court, such true name shall be inserted in the complaint or information and record. Sabi dito, if the true name of the accused is thereafter disclosed by him or appears in some other manner to the court, such true name shall be inserted in the complaint or information and record. Kapag nalaman nila yung pag nalaman yung totoong pangalan ng akusado, kinakailangan na mailagay ito sa complaint at may record. Now, we go on Section 8, Designation of Offense. Under Rule 1110 din to. The complaint or information shall state the designation of the offense given by the statute, avert the acts or omissions constituting the offense, and specify its qualifying and aggravating circumstances. If there is no designation of the offense, reference shall be made to the section or subsection of the statute punishing it. Include na natin dito yung the acts or omission kasi may kaugnayan tong dalawang to eh. Sayang na rin. Section 9, cause of the accusation. The acts or omissions complained of as constituting the offense and the qualifying and aggravating circumstances must be stated in ordinary and concise language and not necessarily in the language used in the statute, but in terms sufficient to enable a person of common understanding to know what offense is being charged, as well its qualifying and aggravating circumstances, and for the court to pronounce judgment. Diba, may kaugnayan nga yung Section 8 at Section 9 kasi pareha sinabi rito yung qualifying and aggravating circumstances. Yun, explain natin yun. So, what are the rules? The designation of the offense requires as a rule that the name given to the offense by statute must stated in the complaint or information. Example, Article 315 of Revised Penal Code, or you may say estafa under the Revised Penal Code. So that is how you designated the offense given by the statute. But if there is no designation of the offense, reference may be made to the section of or subsection punishing it. Sinabi nga dun, di ba? Kanina sa section 8, di ba? Example, ganitong gagawin dyan. Section 11. I'm executing this affidavit to support the filing of criminal case against a violation of Section 11 and 12 of Republic Act 9165. So, that's an example of citing the section or subsection of the law punishing the person with, punishing the person. Okay, saan na tayo? When to be included with the completed designation of the offense is the averment of the acts or the omission constituting the offense. So it is not enough that you will just designate the offense given by the statute. Sabi, hindi daw enough na i-designate mo lang yung offense na sinabi doon. Doon na papasok yung you should state the acts or omission. Complaint of past constituting the offense. For example, in the crime of murder, it is not enough that you'll designate the name of the crime, which is murder. You should state also, or you should narrate the factual circumstances, kung ano yung mga nangyari, kung ano yung mga totoong nangyari, leading to the circumstances that the crime committed is murder. I will give you an example. Like in a spot report. On or about August 21, 2020, De La Cruz went to the house of Archenda, and after a heated discussion, De La Cruz stabbed to death Archenda. Ganon yung i-state o i-narrate mo yung the acts or omission of the offense. Diba? Sabi nga, ganon dapat. Okay, and lastly, the complaint or information must specify the qualifying and aggravating circumstances of the offense. Sabi nga doon sa Section 8 and Section 9. So, if the offense is qualified or aggravated by our circumstances so as to upgrade or to impose a higher offense against the accused, you should state or specify the qualifying and aggravating circumstances. Ulitin ko. So, if the offense is qualified or aggravated by a circumstances so as to upgrade or to impose a higher offense against the accused, you should state or specify the qualifying and aggravating circumstances. So, it is not enough that you just allege the acts or omission. You must specify it to aggravate to higher offense, like from homicide to murder. Example of the qualifying circumstances. Example nito, evidence of premeditation. You should specify it. Example, De La Cruz plan to kill Archenda before he commit it. De La Cruz memorized the daily routine of Archenda. He lists down all of his action every day he goes and wait for the opportunity na nag-iisa na lang si Archenda. So, ganun yung pag-i-specify ng mga circumstances ng evidence of premeditation para yung homicide ay maging murder kasi meron niyang premeditation of evidence. So you should specify them, otherwise you cannot charge the accused with the higher offense without the qualifying and aggravating circumstances. Ganun nga yung sabi rito. Now, for the name of the offended party. So, umpisahan natin. Let us distinguish between a natural person and a juridical person. So, if the offended party is a natural person, you should state the name and surname of the offended party or any appellation or nickname by which such person or nickname by which such person has been or is known. Okay. However, if there's no better way of identifying him, he must be described under a fictitious name, the same lang sa accused. Gaya ng mga Ben Tumbling, Dudong Pampers, yung mga ganong pangalan. If later on the true name of the offended party is disclosed or ascertained, the court must such true name to be inserted. Ganon din, pag nalaman yung totoong pangalan ng offended party, kailangan din may insert siya sa record ng complaint. Now, what if the offended party is a juridical person? Ano nga ba yung juridical person? Nakalimutan ko na eh. Basta. May mga tungkulan yun, yung mga juridical person. Parang matataas na tao. You should state its name or any name or designation by which is known or by which it may be identified. So that's how you should state the name of the offender party if he is a juridical person. Okay. So what if the name of the offended party is unknown and the offense involved is offense against property? If the name of the offended party is unknown, the property must be described with such... okay, ulitin natin. If the name of the offended party is unknown and the offense is involved against property, the property must be described with such particularity as to properly identify the offense charge. Next, dito tayo sa the approximate date of commission of the offense. Under Section 11 of Rule 1110, date or commission of the offense, it is not necessary to state in the complaint or information the precise date of the offense was committed, except when it is material ingredient of the offense. Sabi dito, it is not necessary to state in the complaint or information the precise date of the offense was committed. Hindi daw kailangan na yung mismong date ang ating ilalagay doon. Except when it is a material ingredient of the offense. The offense may be alleged to have been committed on a date as near as possible to the actual date of his commission. Okay, generally, hindi talaga required na exact yung date ng commission of the offense. If you can notice, sa mga cases, ang mga sinasabi nila is that on or about August 25, or sometimes they use this term in alleging date of commission of the offense. Because in the rule, that's not required that you state the exact date the commission of the offense. But there's an exception. If the date is an element of the offense, that's the time that you should state the exact date of the offense. Ito yung exception, ulitin ko. Nasaan na yun? If the date is an element of the offense, that's the time that you should state the exact date of the offense. Yun yung exception niya. Next tayo. The place of the commission of the offense. In Section 10, under Rule 1110, prosecution of the offense, the complaint or information is sufficient if it can be understood from its allegation. Excuse me. That the offense was committed or some of the essential ingredients occurred at some place within the jurisdiction of the court, unless the particular place where it was committed constitutes an essential element of the offense or is necessary for its identification. It is implied from the rule that the description of the place of the commission of the offense must be specific. The law says that you can allege a general averment of the place of the commission of the offense for as long as it occurred within the jurisdiction of the court. But again, just like the date, if it is an essential element of the offense, then you should state it with particularity, kagaya nung sa approximate date. Kung naging elements ng ingredient siya ng essential element siya ng isang crime, doon mo na siya kailangan i-state ng may particularity. It is very important that you can state the place of commission of the offense. As the rule, the criminal action shall be instituted and tried in the court of municipality or territory where the offense was committed, kung saan na-commit ang offense. Ang court na may jurisdiction over that place as jurisdiction over the case. Ulitin ko, kung saan na-commit ang offense, ang court na may jurisdiction over that place as jurisdiction over the case, or where any of it essential ingredients occurred. Remember the section 15 of Rule 110. Yung mga offenses na committed in train, aircraft, or vehicle, or offenses committed on board and vessels. And those offenses covered by Article 2 of the Revised Penal Code. Exceptions din yung mga yon to the rule. So, just take note of them. Now, question. Can you charge 2 or more offenses in one complaint or information? The answer generally is no. Dito na tayo dadapos sa ating pangalawang topic, the duplicity of the offense. The general rule: a complaint or information must charge only one offenses except when the law provides only one punishment for various offenses. But there's an exception to the rule. Example, yung complex crime, Article 48 of the Revised Penal Code. If a crime is a complex crime, that is allowed. So, hindi siya duplicitous. Kasi single lang naman ang kanyang punishment. For this complex crime, second exemption, compound crimes, series of acts, rebellion, under Hernandez Doctrine, and special complex crime. So these are the exceptions of the rule. But generally, you cannot charge 2 offenses in one complaint or information. Otherwise, the complaint or information may considered duplicitous. But the complaint or information that charge more than one offense is considered as defective, but it can be the basis of a valid conviction. Okay, what is the reason for the rule against duplicitous complaint or information? The reason for the rule is to enable the accused to have the necessary knowledge of the charge against him to be able to prepare and prove his defense. Sunod. Next question. What is the remedy of the accused against a duplicitous information or complaint? The remedy of the accused is to file a motion to quash pursuant to Section 3 of the Rule 117. The information remains valid even if it is duplicitous. It is up to the accused to raise or question the defect by filing the proper motion to quash before he pleads the charge. So, ano nga ba ang motion to quash? A motion to quash is a request to a court or other tribunal to render a previous decision or proceeding null or invalid. The exact usage of motion to quash depend on the rules of the particular court. Yun ang motion to quash. What is the effect of the failure of the accused to object a duplicitous information? If the accused fails to object before arraignment, the right is deemed waived and he may be convicted of as many offenses as there are charged if proved by the prosecution. Some situational examples: X fired this gun once, but the bullet killed 2 persons. He was charged with 2 counts of homicide in 1 information. Can he be convicted under that information? Yes, it falls under the exception to the rule. This is a compound crime, in which one act results in 2 or more grave or less grave felonies. The law provides only 1 penalty for the 2 offenses. How does this rule of... hindi na natin isasama to. Now, let's go to the amendment and substitution. Yung ating next topic is all about amendment and substitution and when it allowed. Ano nga ba ang amendment and substitution? Amendment may involve either formal or substantial changes, while substitution necessarily involves a substantial change. Substitution requires that the new information is for a different offense which does not include or is not necessarily included in the original change. Now, let's talk about when it allowed and other things about amendment and substitution of complaint or information. So, with respect to amendment, you can amend the complaint or information before or after the arraignment. However, So, uulitin natin kasi naputol yung sa camera. Cellphone na lang ang gagamitin natin. So, with respect to amendment, you can amend the complaint or information before or after arraignment. However, the difference between the two is that if the amendment is before the arraignment, generally, there is no leave of court that is required. So, you can amend the complaint or information without asking permission from the court. And the amendment, their informal or substance. However, by real exceptions, if the amendment has the effect of downgrades the nature of the offense charged, let's say example from murder to homicide, or if it includes any of the accused from the complaint, if there are 5 accused and they will drop 1 accused, the rule says that the amendments should with leave of the court, meaning to say they should ask permission from the court before you can amend the information or complaint. Okay, there must be a motion by the prosecution with notice to the offended party. But if the amendment is after the arraignment, the amendment should always be with a leave of court, meaning you should always ask permission from the court before you can amend the information. And secondly, the amendment is only for formal amendments, so wala dapat substantial amendments after arraignment. And the accused is not prejudiced thereby. So even if the amendment is a formal amendment, and if it will result of denial of the rights of the accused, then the amendment cannot be made. When can a complaint or information be amendment? General rule. Before plea, a complaint or information can be amended in form or in substance without leave of court. Exemption. If the amendment will downgrade the offense or drop an accused from the complaint or information, in such case, the following requisites shall be observed. 1. The amendment must be made upon motion of the prosecutor. 2. With notice to the offended party. 3. With leave of court. 4. The court must state its reason in resolving the motion. 5. Copies of the resolution should be furnished all parties, especially the offended party. After plea, only formal amendments may be made, but with the leave of court, and when it can be done without causing prejudice to the rights of the accused. When can a complaint or information be substituted? A complaint or information may be substituted if 1. At any time before judgment, it appears that a mistake has been made in charging the proper offense. 2. The accused cannot be convicted of the offense charge or of any other offense necessarily included therein, provided that he will not be placed in double jeopardy. So what are substantial amendments? Amendments involving the recital of facts constituting the offense and determinative of jurisdiction of the court. All other matters are merely of form. Afterly, substantial amendments are prohibited. When can there be an amendment? Before plea, a complaint or information can be amended in form or in substance and without leave of court, except if the amendment will downgrade the offense or drop an accused from the complaint or information. In such a case, the following requisite must be observed. 1. Must be made upon the motion of prosecutor. 2. With notice to the offended party. 3. With leave of court. 4. The court must take reason. 5. Copies of all resolution should be furnished, especially in the offended party. So, when is an amendment considered formal or substantial? Recurse versus CA. He has been held that the test as to whether a defendant is prejudiced by the amendment is whether a defense under the information as it originally stood will be available after the amendment is made, and whether any evidence defendant might have will be equally applicable to the information in the one form as in the other. An amendment to an information which does not change the nature of the crime alleged therein does not affect the essence of the offense, or cause surprise or deprive the accused of an opportunity to meet the new aberment had each been held to be on of form and not of substance. So remember this test determining the amendment whether formal or substantial. So what are the examples of formal amendments? First one, substitution of private complaint. Second, new allegations which relate only to the range of penalty that the court might impose in the event of conviction. An amendment which does not charge another offense different or distinct from the charge in the original one. Additional allegation which does not alter the prosecution's theory of the case. An amendment which does not adversely affect any substantial right of the accused. An amendment that merely adds specification to eliminate vagueness in the information. Now let's go again to substitution, because you already know the amendment. Substitution of complaint or information. A complaint or information may be substituted if it appears anytime before judgment that a mistake has been done in charging the proper offense. In such a case, that the court shall dismiss the original complaint or information once the new one charging the proper offense is filed, provided the accused will not be placed in double jeopardy. So kapag entirely different ang offense, yung i-change mo, the amendment is not proper. what is proper substitution? Now, para malinaw sa inyo, ulitin natin ang distinction between amendment and substitution. Meron tayong illustration dyan. Sana mabasa ninyo. Ang distinction between amendment and substitution, so when you say amendment, it may be made before or after the defendant pleads guilty or not guilty. And in substitution, it may be made before or after the defendant pleads. So both the same. Amendment either formal or substantial, but in substitution, only substantial change is allowed. Amendment is may be with or without leave of court, but in substitution, it always with leave of court. Amendments, informal amendments, is no need for another preliminary investigation and arraignment. So it no have made formal amendments, the complaint or information, there is no need to undergo again in preliminary investigation and arraignment. Because amendment is nearly formal, but with substantial amendments, it cannot take place after arraignment over the objection of the accused. Otherwise, he can invoke double jeopardy. So meaning to say, pag ang amendment after substantial arraignment, if the change is substantial after arraignment, wag mo na lang i-amend. Okay? And if the new crime is entirely different from the old crime, then ang gawin mo, substitution, hindi amendment. But if the crime is necessarily included or necessarily includes the new crime, hindi siya pwede for substitution. Okay? So sa substitution, there is a need to take another preliminary investigation and arraignment. Why? Because you are charging an entirely different offense. Lastly, double jeopardy is not available as the defense in substitution. Because the reason is you are charging a different offense. So ano nga ba ang double jeopardy? Dagdag kaalaman guys. Ating tatalakayin to. So what is double jeopardy? In ordinary sense, double jeopardy means the danger of loss, harm or failure in law. Jeopardy means the danger arising from being on trial for a criminal offense. Double jeopardy as a criminal law concept refers to jeopardy of punishment for the same offense, suggesting that the double jeopardy presupposes two separate criminal prosecutions. Now, for basis of double jeopardy, in Section 21, Article 3 of the Constitution of the Philippines, no person shall be twice put in jeopardy of punishment for the offense. If an act is punished by law and an ordinance, conviction or acquittal under either shall constitute a bar to another prosecution for the same act. Now, the elements of double jeopardy. First, there must be a valid indictment, which means that the complaint or information must sufficiently allege the facts required by the rules of the court. So, the basic requisites for the sufficiency of complaint or information must have been complied with. The double jeopardy will not attach if the complaint or information do not constitute an offense. Second, competent court. When we say competent court, it means that the court has jurisdiction over the criminal case. The requisite for the exercise of jurisdiction must be complied with one jurisdiction over the offense charged. Second, over the person of the accused. Third, jurisdiction over the territory. Now, for the third element, there must be an arraignment because the absence of arraignment results in the nullity of the proceedings before the trial court. Fourth, the accused must have entered a valid plea. So if the accused has entered the conditional plea, then the plea will not be valid, or if the accused made an improvident plea. Fifth, that the case must have been validly terminated. The accused was either convicted or acquitted in the previous charge. The case against him was dismissed or terminated without his express consent. Now, for the effect of WPRD, in criminal cases, WPRD bars another prosecution for the offense charge or for any attempt to commit the same frustration thereof, or for any offense necessarily includes or is necessarily included in the offense charged in the formal complaint. Finality of acquittal doctrine. The accused is entitled to repose as a direct consequence of the finality of his acquittal. This doctrine has several purposes to it. 1. It prevents the state from using criminal processes as an instrument of harassment to wear out the accused by a multitude of cases with accumulated trials. 2. It serves to preclude the state from successively retrying the accused in the hope of securing a conviction. Lastly, it prevents the state from retrying the accused again in the hope of securing greater penalty. Double jeopardy does not apply despite a prior conviction. General rule: a conviction for the offense charge bars prosecution for the offenses. Exceptions to the rule: the graver offenses developed with the supervening facts arising from the same act or omission constituting the offense charge. The facts constituting the graver charge become known or were discovered only after a plea was entered. The plea of guilty to a lesser offense, so for the effect of double jeopardy in civil cases. Next, the acquittal of the accused does not affect the right of the offended party to appeal the civil aspect of the case. So thus the offended party or the accused may appeal to the civil aspect of the judgment. Lastly, for the effect of double jeopardy in quasi-offenses. For the effect of double jeopardy in quasi-offenses, the doctrine that you should remember here is that reckless imprudence under Article 365 is a single quasi-offense itself and not merely a means to commit other crimes. Hence, conviction or acquittal of such quasi-offense bars subsequent prosecution for the same quasi-offense, regardless of its various resulting acts. For example, the accused was charged with two informations. One is reckless imprudence resulting to damage property, and other is reckless imprudence resulting to serious physical injury. But the crime arose from same act or omission. The accused pleaded guilty to the first information. Therefore, he can no longer be tried to the second information because it arose in the same act or omission. So, hindi pwede sa isang act, dalawang reckless imprudence. Dapat ang prosecutor, ang final niya na case ay isang reckless imprudence, tapos i-complex na lang ang mga resulting crimes like resulting to damage of property and resulting to serious physical injuries. So, hindi pwedeng pag-iwalayin yun because reckless imprudence itself is a single quasi-offense. So, hindi siya pwedeng i-divide for as many resulting acts. Now, let's go to the last topic. The place of the place of institution of criminal action. So, what is criminal action? Criminal action, it is one by which the state prosecute a person for an act or omission punishable by law. Institution of criminal offense. Offense for preliminary investigation, file the complaint with the proper officer for the purpose of conducting preliminary investigation. All other offenses, file the complaint or information directly with the municipal trial courts and municipal circuit trial courts or the office of the prosecutor. So, what is the purpose of instituting criminal action? To determine the penal liability of the accused for having outraged the state with his crime, and if he be found guilty, to punish him for it. So that is the purpose. Otherwise, if the accused cannot be subjected to the criminal action, then other people will follow his action. So in order to set an example to other people not to commit the same crime, it is the duty of the state to prosecute criminal offenders. Otherwise, people take it lightly. They will not afraid to commit crimes. So, how criminal action instituted? The answer is, it is depends. If the criminal action required preliminary investigation or not. If it requires a preliminary investigation, then the institution of criminal action will be done by filing a complaint to the proper officer for the conduct of necessary preliminary investigation. So, magpa-file ka ng complaint sa public prosecutor para mag-conduct siya ng PI or preliminary investigation. Kasi nga, the criminal action requires preliminary investigation. If the criminal action is not required, preliminary investigation, you may directly file the complaint to the municipal trial court and municipal circuit trial court. Or you may file it to the private prosecutor if you want. If you can notice, I did not mention Metropolitan Trial Court because there is no direct filing in METC. Sabi ng rules. So necessarily, kailangan dumaan ka muna sa public prosecutor before the complaint filed to the Metropolitan Trial Court. So when you can say that the criminal action requires a preliminary investigation, if the penalty imposed by law is at least 4 years, 2 months, and 1 day, so when can you say that the criminal action requires a preliminary investigation? If the penalty imposed by law is at least, take note, at least 4 years, 2 months, and 1 day. So if the penalty is below 4 years, 2 months, and 1 day, then there is no required for preliminary investigation. And that's all for my oral examination in court testimony. Keep safe po and stay home. Thank you.